Good afternoon. This is appeal number 13 on this afternoon's calendar, matter of People Care Incorporated versus City of New York Human Resources Administration. Counsel?
Good afternoon, Your Honor. May it please the court. May I reserve 2 minutes for rebuttal?
Yes, you may.
Thank you, Your Honor. This case comes down to a basic proposition. Money given under a state-approved contract granting HRA the authority to audit is subject to that auditing authority. First, there is no dispute that we have authority to audit under the contract. Second, there is also no dispute that the company received the earmarked funds, which were meant for its frontline workers under the contract. In January 2003, in accordance with the contract's terms, HRA notified People Care in writing that because of the legislature's appropriation of the earmarked funds, the company's contractual Medicaid payment rate.
If I may ask a question, Mr. Lee, how do you avoid the statement in the statute, the Health Care Reform Act, and in the MOU that says DOH audits and DOH shall recoup?
I'll tackle that separately. First, with respect to the statute is an affirmative grant of authority. It is not an exclusive grant of authority. People Care keeps wanting to read in the words exclusively and only, and that doesn't exist. In fact, if you turn to the MOU, the recital, which People Care agrees is non-binding and unenforceable, says that DOH may audit, which reflects that both parties to the MOU, which is HRA and the state, believe that the statute was an affirmative grant of authority. And I think the real test isn't the plain language, it's the legislative intent. And this court has repeatedly made clear that legislative intent is the driving force and the lodestar of statutory interpretation.
Let's say we agree with that it may, as opposed to it is the only one that indeed does audit or has the authority to audit and recoup. Then what do you rely on for HRA's authority? Is that then because the contract says so and it's a pre-existing partnership with DOH and DOH has in the past delegated it? They didn't need to re-delegate this power?
That's correct, Your Honor. I want to be clear about our position and what I take the state's position to be based on their amicus brief. And that position is that the contract is a pre-existing source of authority in which DOH granted HRA the authority. And not only did it approve the contract, it approved the mechanism by which HRA formulates those contracts. And I want to be clear about why it's important we focus on the contract. And I think this is a background point that I want to bring to the forefront. The contract governs this dispute because the entire personal care services program is run on contracts. This part of the Medicaid program, there's no state institution where you can get personal care services. In order to get personal care services, eligible Medicaid recipients have to be paired with a contracted provider. In this case, that's People Care. And this is plain from the personal care services regulations.
If I can, it's a slightly different question. Let me just clarify this.
Sure.
Because I think this is where the majority was in the appellate division. So are you saying there is no other way other than by treating this as money that is dispersed pursuant to the contract? There is no other way that People Care could have gotten this money but through the fact that they had a contract with you. That is to say, the statute on its own, once there's a certification, doesn't mean that you just give out the money. Is that what you're arguing? I just want to understand sort of your point about that.
Yes, that's absolutely correct. Because again, without a contract, the provider isn't entitled to money. We're not just handing out these to any company, so to speak. You have to be a contracted provider. And if there's any doubt about that, the record is very clear on this. Page 157 of the record is a letter in which HRA explains how the earmarked money under the Health Care Reform Act is going to affect People Care. And it says your contractual rate is $13.75 an hour. And that's confirmed if you look at the contract on page 74. You'll see in the contract that was their existing rate, $13.75. But because of the earmarked funds, the legislature's appropriation, that rate goes from $13.75 to $15.10. And the letter explains how it actually is going to be dispersed under the contract. And just to give you some background, all of these contracts that HRA formulates, there's two components, what's called direct labor, which is paying the actual personal care service workers who deliver the care. That could be feeding, that could be grooming, that's cooking, getting prescriptions for the elderly individuals. And then there's what's called indirect labor, which is sort of administrative costs to run the business. For nonprofit, go ahead.
Can I just ask you, I just want to make sure I understand and see if I can simplify the argument a little bit and make sure I'm not misstating it. Are you saying that the funds received pursuant to HICRA are Medicaid funds like any others? They just come from a special revenue stream, I think is the language that's used, but they're treated exactly the same as all of the other Medicaid funds that are funneled or dispersed to the providers for these personal care services?
That's correct.
Okay.
Funnel is the perfect way to use it. The contract is a funnel. There is an existing stream of money, and the legislature says, let's add another stream of money going into that funnel. And the legislature was clear on that. It said specifically, we are supporting the state's share of this rate.
Is
and
this common? Is this commonly done, or I mean, is there something that differentiates this from other special revenue streams?
There's nothing uncommon about this. I think, as the state explained in its amicus brief, Medicaid funding comes from a lot of different sources. And if you look at this particular statute, 2807V, Medicaid is mentioned.
Mr. Lee, it is clear that this is earmarked, though.
Yes, that is the one thing.
Particular services and for labor. It's not, you can't use it for everything else. It's not a general funding stream.
That's correct. The one difference actually cuts in our favor. It's that the legislature said, we're going to give you a contractual rate increase. And that's because the state and the federal government split 50-50 on this particular Medicaid stream. So they're saying, we're willing to pay a little bit more to make sure the workers get paid more. And here's what an earmark. Yes, Judge.
Just to follow up on Judge Rivera's question, the earmarking of the funds, the legislature receives revenue from a variety of sources, and then it passes a budget and it marks where those variety of revenue sources go. When this money comes in, as you said, there are a variety of streams, and Judge Rivera used that phrase too. I think a variety of streams that go in here. Have these funds, as I understand it, from the tobacco settlement, were all directly, I forget whether they all, these particular funds were all directly targeted for Medicaid use programmatically. Is that correct?
This particular stream, yes, it's correct. It was targeted for this particular program. I just want to explain two things about this. It's called the Tobacco Litigation Fund, but it's not just tobacco litigation. It's also other taxes, and it's a very long statute. If you read it, you'll see the different sources that come in. The main source, I believe, in the beginning was tobacco litigation, but it since encompasses a lot of different sources. The funds that were
going to be audited, were they used for any other purposes than Medicaid-related purposes?
No, they only intend, this is why it's Medicaid money. It was given to a Medicaid provider, People Care, to provide a Medicaid benefit, personal care services to qualified recipients. And the only intention that the legislature said, and it said in the statute, it was to make sure that these providers could better retain the individual workers who deliver the personal care services. Because I think, as this court knows, these workers are very low paid.
On a different point, Mr. Lee, in reading the appellate division decision, it seemed to me that it read like they felt that they were constrained by their 2011 decision in this matter. Do you agree with that?
I think that is how the majority felt, but I think
tell me why you think that.
Well, I think that because they had language in the opinion that suggested that they had necessarily decided the contractual issue. But I think, as the dissent pointed out, that's just not correct. Nowhere in that decision do they say that they decide that issue. And in fact, they remanded this case to determine, as dissent points out, whether or not HRA was in fact authorized to do that. And after that remand, we submitted evidence. In this case, on the remand, we submitted an affidavit from the state's CFO that runs Medicaid explaining exactly how this works. And I think the majority just got it wrong in believing that they were constrained by that 2011 decision.
Is there any other auditing function that let me phrase this again. does HRA have any other auditing function with Medicaid funds that they are not allowed to do, as the appellate division has done here? They aren't allowed to audit a particular area. Is this the only area of Medicaid funding where they're restricted in their auditing, both recoupment and auditing abilities?
I think that's yes, based on what the first department has done. I mean,
Right.
I think it has disrupted the way that HRA and the state work together to make sure that there is integrity in Medicaid spending.
Well,
Thank
thank you. Thank you, Judge.
Counsel?
Good afternoon, Your Honor. Thomas Fleming for Respondent People Care. If I could just, as an aside, note that at any time over the past 15 years, the Department of Health could have audited these funds. We haven't hid anything from anybody. The DOH has a website devoted to HICRA,
But
mentioning all of its audit powers.
Counselor, in all fairness, does DOH ever audit Medicaid funds that are distributed by HRA pursuant to a contract for personal care services?
Well, this was not distributed pursuant to a contract for
Well,
personal care services.
That's sort of the crux of the case, isn't it?
I agree, Your Honor. And let me explain why I say that, because it is the crux, Your Honor. These are fundamentally not Medicaid funds. The HICRA grants come from the Tobacco Control Initiative pool, and they are targeted for a specific purpose. They're not aimed at going to the needy. They're aimed at going to the people, the personal care attendants who serve them, and they go to recruitment and retention. There were specific amounts for specific years targeting specific individuals. Medicaid was simply, and the Medicaid rate add-on in the system was simply the way to get the money to the intended recipients, who were the personal care attendants.
Another question: has People Care ever received any funds through HRA for personal care services other than Medicaid funds?
They've received Medicaid funds, which is the standard, what we have under the contract. They receive a set rate based on the number of employees they have and the work they're doing. They've received these funds, which are targeted at their employees for recruitment and retention. They've received additional funds, also through the Tobacco Control Initiative, for what's called the Home Care Worker Demonstration Program, which is
Fleming,
also
if I can just interrupt you, I think it's apropos of Judge Stein's question. If the contract says that here's the ARM, here's the rate, this is the labor, the hourly rate that the labor is going to be paid, and you've just now said that there's Medicaid funds that goes to this contract, why isn't this other source of funding for the cost of wages also Medicaid funds? You are already there is already Medicaid funding going to the hourly rate. This is just more money to get you a higher hourly rate. It's still Medicaid funding.
Your Honor, I respectfully think the court misapprehends what the statute is here and misapprehends our contract. What the contract provides is we get to keep what are termed allowable payments, which is the hourly fee that we get, and that covers our direct labor, overhead, and a profit. These funds that we got are not part of the allowable payments. They have a totally different track, and they don't go to labor. They don't have to go to the individual employees to pay them additional funds. They go to recruitment and retention, which is a wide variety of things that we could be doing with them that don't fit into any of these categories. And in this case, as we allege,
yes, I understand, but as you will correct me if my understanding of the record is wrong. As I understand, what happened here is you put in your certification, HRA approves it and tells you, okay, this is how the additional money is going to be spent. It now it increases the hourly wage. Did you object to that and say, no, I don't want to use it for that?
No, the HRA did not tell us how the money had to be spent. The statute and the MOU tell us the money has to be spent for recruitment and retention. It was not required to be spent on an annual cycle, which is part of the problem here, because HRA audits the Medicaid funds on an annual cycle.
It still sounds to me, if I can interrupt, it still sounds to me that what you're disputing is whether or not you misused the funds, which is not really the question, right? Well, the question is whether or not they have authority to audit and determine for themselves whether or not you have misused the funds and they want it reimbursed. You can say we didn't misuse the funds. That's a different issue, but that's not the issue before us.
Well, the issue when they exercise their authority under the contract, Your Honor, it's not a question of misuse. Their position is that we didn't spend them. So we spent them after the contract.
Yes, but either way, that's not the question before us. The question before us is whether or not they're authorized to take a look and then based on their determination to demand reimbursement. Again, you could say, well, you're wrong. I've complied with the law and I don't have to give it back. But that's not the question before us.
Well, Your Honor, I respectfully submit the question before the court is when you look at the contract, that these funds and the whole recoupment mechanism that's set up in the contract has no application. There's no way they can measure them under the contract. And with the first department,
you agree that DOH would have the authority to audit and recoup these funds, correct?
Absolutely, Your Honor.
Okay, so what is the difference? What is the practical difference to you, whether that process, whatever the permissible process may be in your view, what difference does it make whether DOH does it or HCA does it?
It's a huge difference, Your Honor, and it's a huge difference because the audit and recoupment process that's under this contract goes off of an annual cycle. So as a result of the annual cycle, we were caught in a trap where we had actually spent the money. The audit takes place years later, and we had spent the money after the audit. And then they said, well, you didn't spend it during the audit years, so now we want it back. But it's already been spent.
If we were to determine, or whatever the process is in your contractual, or whatever the appropriate process is, if it were to be determined that it was irrational or improper or illegal or whatever, to base it on an annual allotment, right? It doesn't matter whether that whole process is followed by HRA or whether it's followed by DOH. That's what you are really contesting, is whether that method of recoupment is appropriate, right? Or auditing and recoup.
Well, that's certainly essential to our objection, but that error, we believe, reflects a larger gap in the HRA's authority because they don't have their sole mechanism as an annual one. And the fact that they make this very obvious and serious mistake, which, by the way, the CDRB has, in another parallel case, has ruled they can't do. But the fact that they make that mistake reflects the fact that they are treating these as general Medicaid funds when they are not coming from state and federal funding of the social services law. They're coming through a special set-aside program with targeted purposes to help our employees and coming to us with some discretion over when we use them and with accountability, we believe, only to the Department of Health. And that's parallel to the other program we're in, which is the Home Care Worker Demonstration Program, where we also receive money that was targeted for our employees and to help with their insurance benefits.
But if I may ask, they would, if you're not, to Mr. Lee's point, if you do not have a contract with HRA, there is no service for the government to pay for. Is that not correct?
Well, we have to have the way these were computed, because they were going to employees or home care attendants with direct patient services to help the needy. So you'd have to have a contract to be reimbursed for those type of services.
Right,
but,
but the needy in this context are Medicaid recipients, are they not?
No, the beneficiaries are our employees.
No.
So they're home care attendants.
But the people who gets the service, the people who get
Yes,
the home care
absolutely.
service, they are all Medicaid recipients, right?
Correct. This program, we have a contract with the city, and we provide home care attendant services to a certain number of individuals who are Medicaid recipients in the four
So then,
boroughs.
but for the Medicaid program, there would be no basis for you to get any funds.
Correct, Your Honor.
Regardless
This was
of the source.
I believe that's correct, Your Honor. And this was a program that was set up to help those who are providing services to the needy by giving funds to their employers, which in that case is People Care, so that they could use them for recruitment and retention, not to any of the components in this contract that we have. And that's
yes, as I understand, and you will correct me if my understanding is wrong. As I understand it, that is the legislature's concern with inappropriately low wages for people who provide these services, and to ensure that you get quality services going to the individuals who are the Medicaid recipients, correct?
Well, but I don't think the legislature's concern was limited to wages, because otherwise they would have just said, use it as additional compensation. And we weren't required to use it as additional compensation. It could be used for training programs, anything that would provide for recruitment. All of those were valid services. And I would ask the court to, I think the first department, really the majority there, did get it correct when they observed that the contracts we have do provide for amendment if the Department of Health changes the method of reimbursing the contractor. And I submit that's what happened here. They changed the method. We weren't getting paid on the allowable payment formula with a profit margin or anything like that. We were getting paid as a pass-through for a specific purpose, which was recruitment and retention. And that's what they did. And that the audit and other powers of that associated with those pass-throughs remained with the Department of Health, which is what the MOU indicates and what the statute indicates. And I see I'm out of time, Your Honor. If the court has any more questions, I would be glad to help them. And I ask the court affirm the first department ruling.
Thank you, counsel. Mr. Lee, what is the harm if it were determined that the audit of the HICRA funds must be done by DOH and not by the local social service?
Here's the harm, Your Honor, and it's twofold. One, People Care in this very litigation has actually argued that DOH does not have the authority to audit any of the money except for the HICRA funds, and they have said that they are subject to a 6-year statute of limitations. In other words, my opponent has here said DOH can at any time decide to audit. That's actually not true. That's just at page 181 of the record. They argue that DOH is barred. And so basically, they have litigated this case such that DOH can't actually audit. And in fact, DOH has told us we are not going to audit because we trust you. You have the expertise. They have approved our contracts and our way of doing things, which is a lower, more cost-effective rate since 1981. That's 4 decades that they have trusted us to do this. There is no need, and it makes no sense, to interpret a statute where the legislature was very much concerned about fraud. And I think this case is emblematic of that, to say, oh yeah, the legislature is going to unilaterally disarm the ability of the state to work with their local agencies who best know their providers to say, we don't want you to audit. I just don't think that squares, frankly, with the legislative intent. And that's the harm.
Chief Judge, may I ask a question? Counsel, could you, as part of that answer, address your adversary's point on the harm to his client by allowing you to audit, your client to audit?
Absolutely. I think his argument rests on the fact that it's done on an annual basis, and that's not a harm here. In fact, the state and HRA has taken the position that all Medicaid money needs to be audited on an annual basis. This is government money. That's how it works. If it's not spent on the needy, it gets reallocated, and the state takes it back and uses it for other purpose. And my client tells me that when we audit the HICRA funds and we audit what he calls the regular Medicaid funds, it's not segregated. It all goes to the same bank account, and the state credits that as Medicaid money. So he's saying that they didn't know it's done on an annual basis. But the basic
Mr. Lee, you've frozen. Well, your light's on anyway.